The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Well, welcome everyone to the Fourth Circuit Court of Appeals today. We have two cases before this panel, and afterwards we have a third case that the panel will change just a little bit, and then Judge Quattlebaum will go forward in the next panel for one case. But we'll begin with Walmart Real Estate Business Trust et al. Number 2019-27 against Quarterfield Partners and Mr. Baldwin. It's good to have you with us, sir, and you may remove that mask. Go right ahead.
Good morning. May it please the court. I'm Rignall Baldwin from Baldwin Serena on behalf of appellants, Quarterfield Partners. There are a number of different appellations in the caption of the case. For simplicity's sake, I will simply be referring to Quarterfield and Walmart.
Very good.
This case concerns a commercial lease agreement between two sophisticated parties, Quarterfield and Walmart. Ruling on motions, cross motions for summary judgment, the district court was required to construe a section of the lease agreement between the parties that contemplates the potential sale and purchase of the premises. The contract is governed by Maryland law, and under Maryland law, courts construing a contract must first determine if the language
is governed by Maryland law.
Yes, Your Honor. Under Maryland law, courts construing a contract must first determine whether the material terms are ambiguous. Ambiguity only exists if a provision is reasonably susceptible to more than one understanding. In making the determination as to whether or not the contract is ambiguous, the trial court looks to the four corners of the document to gain better understanding of the provision that is in dispute. In this case, both parties argue that the contract provision is unambiguous.
Now, the district court was acting through the magistrate judge and granted summary judgment against you.
Yes, Your Honor.
On what, 2 counts?
It was specific performance and a declaratory judgment action. Damages have been left to later.
Damages are in count 4.
Correct.
Now, how do you get jurisdiction up here?
Both parties in the contract itself consented to the district court consented to Maryland courts for jurisdiction and chose Maryland as their choice of law.
So what's your basis, I think?
Go ahead.
Your basis for jurisdiction in the federal court as opposed to the Maryland state court?
It is I believe, a diversity jurisdiction case. There are actually addendums to the contract that deal with other venues, but it's my understanding that both parties consented to this Maryland and now this circuit as the court to dispose of any disputes.
No, but we're a court of limited jurisdiction, and you normally, in the Court of Appeals of the United States, you can only come up on a final order, a final decision of the district court, and you don't have one here.
I misunderstood. I apologize.
Yeah.
for appellate jurisdiction,
Yeah, that's what I was talking about.
both parties agreed that because of the specific performance aspect of the lower court's decision, the appellants requested leave to do an interlocutory appeal. I believe that appellees consented, and the district court so ordered. So we are here because the declaratory judgment and the specific performance aspect of it essentially makes it final as to the ownership of the property, and damages have been left now.
Is there a controlling, or what is the controlling question of law in the case?
The controlling question of law is essentially whether or not the district court correctly followed the judicial rules for construction of an ambiguous or unambiguous term in the contract.
Well, that's the ruling of the court in the case. I'm talking about under the statute that you purport to have jurisdiction under section 1292B, there has to be a controlling question of law as to which there's a significant basis for difference of opinion. Controlling question of law, significant basis for difference of opinion. And so the law has to be disputed.
If I understand the question correctly, the dispute between the parties is the correct construction of Section 27.
And you're applying Maryland law. It's not anything about federal law.
It is exclusively Maryland law.
Exclusively Maryland law, and it's a ruling of the district court on what this lease is all about.
Yes, Your Honor. The district court reviewed the section, the title of which is irrelevant, but refers to an option to purchase or a purchase option. The dispute revolves around what Section 27 says about any condition precedent that would ripen the option in order for Walmart to exercise it, and the timing of when the option is exercisable. Section 27 of the lease is clear in that it states unambiguously that the option period, which is a one-year period, shall not commence until Porterfield sends notice to Walmart that the option period has begun, and 2 notices are required. The district.
Counsel, did you, on either the commencement issue or the option issue, you understand when I describe them that way, what I'm talking about? Did you argue that either of the provisions on those 2 issues were ambiguous, or is it Porterfield's position that both are unambiguous?
It is Porterfield's position that both are unambiguous.
You didn't alternatively argue that if our position on how they should be unambiguously interpreted, you didn't alternatively argue that if we're not right, they're ambiguous. So it's all in on not being ambiguous, correct?
In our briefing, we address what would be the proper method of construction for Section 27 should the court find an unresolvable apparent ambiguity. So, for example, the phrase option notice is a defined term, and it is used in the same way for the seller, the potential seller, as the potential purchaser. But it becomes clear simply in reading that section that one is the option notice from the purported seller, and the other is the option notice from the purported buyer. So our argument is that it is unambiguous. However, we believe that the parole evidence supports the language that is in fact used in the contract. And the construction of the contract.
So your position is, if I understand it, that the Quarterfield had the sole control over whether or not there would be an option. You didn't send the notice, there's no option.
No, Your Honor. We argue that the option exists, but that it requires something to trigger the option. So the option exists, but so, for example.
If you don't send the notice, how does the option work?
It does not begin until Quarterfield sends the second notice. And that is giving a party control over a conditioned precedent. However, it does not render the section illusory.
Why is that an option? I mean, I don't understand what purpose the option serves if you can control it in that way.
It is a very limited option, and it is a limited option that came about from multiple revisions by teams of attorneys of this contract between the lessor and the lessee. And that is one of the difficulties in reviewing a complex commercial lease, is that one is not often enlightened as to why the parties did what it is that they did.
Because it certainly doesn't make any commercial sense, to
Well,
me at least, is why, you know, one sophisticated entity like Walmart would agree to that.
So, for example,
If you decided not to send the notice, all your client has to do is to call up Walmart and say, well, we're not going to send the notice, but if you want to buy, the price is now X plus 10.
when the lease negotiations began, Walmart took the position that they preferred to purchase property rather than lease it. They did not want to lease the premises, they wanted to purchase it. Quarterfield demurred, and the negotiations continued over 18 months. In the end, Walmart was able to record a non-binding, non-applicable short-form memorandum of lease that publicly showed that they had a purchase option on the property. For whatever reason, that was important, apparently, to Walmart, that they always had a purchase involved in their negotiations. But in fact, much like a contract to lease a certain number of square feet, the landlord will sometimes not want to reduce the dollar per square foot figure, so we'll simply say, it is X dollars per square foot, we won't budge on that, but you get 1 month free.
So that is, we can, I guess, debate whether what people were thinking or might have mattered, but to the extent that matters, it sounds like you're saying Walmart wanted to be able to tell the world that it had an option, but then the actual agreement undid that, for lack of a better word, or at least limited to it the extent that you had absolute control over it.
It did, and that is the language that comes after notwithstanding the foregoing. In section 27.
But it doesn't say that. You interpret it that way. I mean, for example, it could have said Quarterfield has, in its sole discretion, can decide whether or not to send the notices. Now, it also could have said other things that might have clarified it more the other way. But, you're asking us to interpret the language that way. In fairness, it doesn't explicitly say what you say it means, correct?
It says explicitly or expressly, notwithstanding the foregoing, the option term shall not commence until the lessor sends the lessee 2 30-day notices. And that, to me, from our perspective, is unambiguous. And the most important exercise is the examination of the language itself without wondering why it is that two sophisticated parties, neither of which have alleged fraud or mistake, would agree to it. It is undisputed, even in this case, that both parties did agree to the language in Section 27.
So there's no question of law here at all. Not much less a controlling question of law. The law is not disputed in any way, shape, or form. Let me tell you something. It isn't very often that I write opinions around here that turn out to be published, and it might be precedent along the way. But I had one in a case called Agape, United States versus Agape, 848, Federal Reporter 3rd, and I refer you and your clerks to page 340 and 341, which talks about 1292B of Title 28, which requires that the order being reviewed has to be a controlling question of law as to which there is substantial ground for a difference of opinion, and an immediate appeal from that order must promise to materially advance the ultimate termination of the litigation. But 1292B, we said, and that's precedent, should be used sparingly, and its requirements must be strictly construed. And you don't have a controlling question of law. You don't have a certification from the district court as to what the question is, even. Just that there is she said there is a controlling question of law, but you haven't been able to articulate what it is. And it's Maryland law to begin with, not federal law.
Your Honor, I see that I'm out of time, but with your permission.
No, you can answer. I don't know what I've asked a question, but I don't know why somebody didn't find these authorities with respect to 1292B. And I don't know why Walmart didn't make a motion to dismiss, but they didn't. Because they want to have the appeal heard, I guess. But there's a count 4 about damages in this case. So it's not a final order, and that's not resolved. The count 4 is still there, but that's your hook for federal jurisdiction. That's why you don't want it taken out. I understand that.
Your Honor,
But you don't have a final decision, and you don't have one that's properly certifiable under 1292B. I don't think, looking at the authority, and I've given you the case, I think, and it's a published authority, unless I don't read it right, unless I was dead wrong when I wrote it.
I do not believe that's possible.
Right ahead, answer that commentary however you like.
From a practical perspective, if the premises, if the order of the court is carried out, even exclusive of damages, title shifts from Porterfield over to Walmart. It would then take quite some time to return to attempt to undo that transaction, and we would be looking at basically balancing monetary damages related also to the exchange of the property. I regret not having the correct answer for your question, apparently. All I can say is that as a practical matter, if the appeal is not decided in this court, it puts both parties much further down the road towards a type of irreparable harm, in that Walmart would have attempted to purchase the property, then purchased the property by judicial order. Rent has been paid into escrow since that order, so those funds would then transfer. But I understand the question, and that is the best I can answer it.
Very good, sir.
Thank you.
Thank you, Mr. Baldwin. You saved some time as well. Mr. Breckenridge? You're here for Walmart and Sam's.
Good morning, Your Honor. Yes, may it please the court, Tillman Breckenridge on behalf of Walmart Real Estate Business Trust and Sam's Real Estate Business Trust. I'd like to begin with the first sentence of Porterfield's conclusion to its reply brief. At page 21, they encapsulate their theory of the case. Quote, Section 27 provides appellants with the right to decide if and when the properties will be offered for sale. Now, if we sort of let that sink in and think about it, Porterfield's theory of Section 27 is that it gives them a right that they just inherently already have as a property owner, the right to sell it to Walmart. They don't need a contract to say that, and certainly not language cased as an option to sell.
We
to another
understand,
party.
I think, the back and forth between the parties, both on brief and otherwise, as to how this contract should be construed, or contracts. But what's your response to the questions Judge King has put with respect to appellate jurisdiction? I mean, are you all authorized to be here?
Well, Your Honor, I do believe we are authorized to be here. Under the text of Section 1292B, there is a controlling question of law that you could get to, that the district court did get to, as to whether or not Porterfield's interpretation is illusory under Maryland law. And while we wouldn't agree that there's ground for substantial difference of opinion, I suspect that appellees
Well,
don't
it has to
tend
be
to
a ground
agree.
for, substantial grounds for difference of opinion. That's in the statute.
Well,
That's
yes,
in the statute. It has to be that, or you don't have jurisdiction.
yes, Your Honor.
You actually, I think you all do, actually argue that there's 1291 jurisdiction, final order jurisdiction. I
No,
think.
Your Honor.
Also, in the alternative, or is that the other side in their brief?
That's the other
Oh,
side.
they actually brought it up. They recognized at some point that they may have a flaw with this 1292B, and they threw out 1291, but the count 4 undermines that, right?
Yes, Your Honor, count 4 undermines 1290.
Count 4 undermines that. They want the damage claim in, so they have diversity. That's the only hook. It's all state law. This thing belongs in JP court or something.
Right, Your Honor. I'm not aware of a requirement that the controlling question of law be a question of federal law, though.
Well,
And
the statute is very clear, and I gave you the case. And that, like it or not, that's what the statute says, and we apply it strictly, or have applied it strictly. We say it should be applied strictly. There has to be a controlling question of law as to which there's a substantial ground for difference of opinion. It will help resolve the case down the road.
yes, Your Honor, and on the point of a substantial ground for difference of opinion.
You all can't agree on what the controlling question of law is. And it's got to be state law. That's all the law here is, that applies to this is state law.
Yeah, I agree that it's state law, Your Honor, and I agree that.
The question is
I would
the question is
disagree with
whether
Your Honor
the question is whether the contract is, or the leases are ambiguous or not.
Well, that is partially what we're here regarding, because if you don't get to the ambiguity, which we don't think the court should get to the ambiguity, then, the alleged ambiguity, and the alleged ambiguity is not on whether there's an option, but on the starting of the option term and when it started. Or at least, I shouldn't say that, I apologize. The other side does say that there's a difference of opinion on whether there's an option at all. But as far as the district court was concerned, the district court only ruled that there was an ambiguity on when the option term starts.
So
But
tell us, what is the question of law as opposed to interpretation of a contract?
the question of law is whether or not the Porterfield interpretation of the contract renders the provision illusory. That's the only question of law that I really see. And while we don't agree that there's a substantial ground for a difference of opinion, that doesn't necessarily mean the court apparently found one in granting the 1292B.
Well, you agreed there was 1290B. You agreed with the petition for appeal under 1292B.
I believe we didn't
So you
oppose.
had to agree, did you not?
I believe we didn't oppose it. That I don't believe.
Well,
that
all
we
right,
agreed.
you didn't oppose it.
Yes, Your Honor.
You wanted the advisory opinion from the court.
Well, Your Honor, I don't think it would be an advisory opinion. It would be an opinion.
Well,
on-
if we don't have jurisdiction and we give an opinion, it's an advisory opinion.
Well, I agree, Your
We're a
Honor.
court of limited jurisdiction. We have the jurisdiction that Congress gives us, period.
Yes, Your Honor, and I agree. And so to the extent that the court found that there was a substantial ground for a difference of opinion in granting the 1292B, we would disagree with that, but we as Walmart and Sam's are not in a position to disagree with the court as to whether or not there's a substantial ground for a difference of opinion. And so we went ahead and briefed the case and showed up for argument on that ground because the district court and this court granted the 1292B and the petition for permission to appeal. Unless there are any further questions or questions on the merits, then Walmart and Porterfield will submit.
Thank you very much, Mr. Breckenridge. Mr. Baldwin?
To the extent that I am more prepared to argue about what we should be doing once we've gotten here rather than whether or not we should be here, I apologize. But
You're not prepared to argue jurisdiction? Appellate jurisdiction?
I believe that the issue that this court can resolve and it is, I do not want to speak for my opponent in stating that there is a dispute that is controlling, but the question that we ask that this court resolve is essentially whether or not it is appropriate for the district court to consider extrinsic evidence or to inject conjecture or strained interpretation into a contract in order to give it the effect that a party now argues it should have rather than the effect of the words in the provision itself, construed in the context of the document as a whole. Our position is that extrinsic evidence was not necessary in order to construe the contract because the contract's terms, when considered in the context of the parties and what a reasonably prudent person would read the plain and ordinary meaning of those words to be, speaks of a purchase option, then imposes a very high bar for its ripening, and that is that Porterfield issue notices, speaks to a time period when the parties have agreed that the option may be exercised or, at Porterfield's discretion and choice, well, how that option period can be deferred from year to year throughout the lease. But it is not illusory in that it most certainly binds both parties to do certain things upon the occurrence of a condition precedent. The district court held that the option notice, which was a right that Porterfield held, could be waived by the person who did not, in fact, have the right to waive that contract provision in that it benefited, at minimum, one party, but presumably both, considering the purpose of the contract as a whole, which was the lease of property. So, in the district court's opinion, the resort to extrinsic evidence to try and make sense of something that appeared either irrational or nonsensical is an error in that the language itself is clear and a party cannot later complain that they did not agree to the words that they agreed to because it doesn't make sense. So the district court, instead of looking to the four corners of the document as we argue that it should have, resorted to an explanatory exercise of why the contract term essentially needed to be changed, why the notice provision changed from a right that Quarterfield could exercise to a right that Walmart could exercise. The court held that notwithstanding the plain language of the section, that somehow Walmart had the right to waive Quarterfield's notice, which commenced the option period. The construction of this lease, capital L defined term, was changed from the effective date of the lease, which is agreed to in an amendment, I believe it's Amendment 17 to the contract, that fixes dates, changed from that to the rent commencement date. Simply changed periods in order to make the argument that Walmart was entitled to purchase the property at its discretion fit within the words in the contract. And without any additional questions, that is our argument.
Thank you very much, Mr. Baldwin.
Thank you.
We have a grand tradition in this court that after each argument of counsel, we on the bench, the judges, leave the bench and come down to the well of the court and greet the lawyers, shake their hands and tell them they've done a good job and we're not glad to have them here. And we have suspended that exercise of that tradition because of the pandemic, and hopefully going to get back to it by the time you all are here again. And but we're not going to be able to do that today. We want to thank you for being here, and your appeal will be taken under advisement. And thank you very much.
Thank you, Your Honor.
Madam Clerk, we'll rearrange. Able to get around the council table? Good to have you all here. Go right ahead, Madam Clerk.
All right. We'll call the next case, Truck Insurance Exchange versus Kaiser Gypsum Company.
And the appellant truck insurance company, Ms. Ho, good to have you with us.
Thank you, Your Honors. Good morning, Your Honors. May it please the court. Bankruptcy law can be complicated, but this case is not. A plan that strategically enables litigation abuse cannot possibly be proposed in good faith as the bankruptcy code requires. Since the Garlock bankruptcy uncovered rampant, systemic litigation abuse by counsel for asbestos claimants, all asbestos trusts created under Section 524G have included basic anti-fraud protections. All that is, except the plan confirmed below. The lack of fraud protections has always been Truck's primary objection to the plan. In fact, Truck offered to withdraw all of its objections and support the plan if it simply included anti-fraud protections like every other post-Garlock plan. The claimant's refusal to do so, going so far, yes,
You
Your
all talk
Honor.
about that Garlock case, that's not a Court of Appeals case, or there's precedent here. It's a bankruptcy judge's opinion in the Western District of North Carolina.
Yes, that's correct. That's correct, Your Honor. And it has then served as the model going forward, the protections, the fraud uncovered in that case, and the protections adopted to combat that fraud in the wake of that case have been adopted in every contested 524G trust that we're aware of since then.
But we're not,
I'm sorry.
but we're not bound by Garlock in any way.
No, Your Honor, and our argument isn't that you're bound by it. Our argument about Garlock is really twofold. Number one, that the rampant fraud uncovered by the discovery permitted in Garlock is the reason why every trust since Garlock has adopted the same anti-fraud provisions that we're asking for here.
You're saying it's been marketed around the country.
I'm saying that bankruptcy judges around the country have refused to confirm plans since Garlock that do not include Garlock-type protection. So, for example, Your Honor, the Marymount bankruptcy that we discussed.
It's not precedent here.
No, Your
It doesn't
Honor.
control us
No,
in
no,
any way, shape, or form. It may be persuasive and all that, but it's not precedent.
no, Your Honor, and we're not citing it to this court as precedent. We're relying on Garlock for the proposition primarily that the plan here could not have been proposed in good faith when it refused to include the same anti-fraud provisions that every post-Garlock plan has included.
I'm sorry, go ahead.
How is Truck in any different position in the bankruptcy than it would have been before the bankruptcy, facing its insurance contract obligations?
Yes, Your Honor, and that seems to be the other side's primary position on standing, that because we were subject to fraud before, a plan that facilitates fraud, we shouldn't have standing to object.
Tell
Yes,
us
Your
how
Honor.
they're in a different position now than they would have been before the bankruptcy.
Yes, a couple of reasons, and let me start with our standing to challenge the good faith proposal of the plan. The plan facilitates fraud, and it deprives us, Your Honor. Yes, Your Honor.
Hold up.
Yes.
Wouldn't you start with the insurance neutrality part?
Certainly, Your Honor, I could.
As long as the plan is insurance neutral, where do you go from there?
Certainly, we disagree that the plan is insurance neutral. Before the plan was approved, we had a coverage defense about the duty of cooperation. After the plan was approved, we do not have that same coverage defense. That coverage defense was resolved against us, and it was given preclusive effect. So we don't think the plan is
But there's
insurance neutral for
specific
those reasons, Your
provisions
Honor.
in the plan that say that all the cooperation obligations survive the bankruptcy.
Yes, Your Honor, that is what the plan may say, but that is not the test for insurance neutrality, Your Honor. The test for insurance neutrality is have the insurer's rights been abridged or affected in any way? Because again, this is a standing doctrine.
So is there, counsel, on this point, is there, I mean, I understand your argument that, you believe the cooperation clause, entitles you to assert the defense that the Kaiser's, I guess, role in the confirmation of the plan breached that duty. And then there's, of course, the other side that says, hey, that duty really applies on a case-by-case basis. What's your best case that says this cooperation obligation applies here to a broad-based conduct like like participation in a bankruptcy plan? What's the closest case to something like this that extends that cooperation agreement to what we have here?
Thank you, Your Honor, for that question. I think our best two responses. I don't have a case that directly responds to their argument because, Your Honor, it's simply the language of the plan is clear. It applies to they are obligated to cooperate, comma, and then the plan goes on. So it's a standard provision that, so far as I'm aware, has never been challenged to apply in a circumstance like this. I think our best case on insurance neutrality overall, Your Honor, is the Seventh Circuit's decision in C.P. Hall, where the court, even though that case held that the insurer there didn't have standing, the court went on to say, but insurer clearly would have standing regardless of insurance neutrality. In a case where there was a scheme between the debtor and the claimants that directly affected the insurer, and that's exactly the case that we have before you today, Your Honor.
I'm sorry, go ahead. I'm back to the question I asked you some time ago. How is Truck in any different position now than it was before the bankruptcy?
Let me try it again another way. Let me focus on what I was just talking about with Judge Quattlebaum about the coverage defense. Before the plan, we had the ability to assert a defense to coverage. After the plan, we don't have the ability to assert that, and that was given preclusive effect. And this court has said that the preclusive effect is enough for standing. Yes, Your Honor.
Tell us why you say that when there's a specific provision, I think two of them at least, in the plan that says all those defenses survive.
Yes, Your Honor, because this court does not look just to what the plan says about insurance neutrality, but what the plan does.
That we aren't aware of, or?
It is the part of the confirmation order, Your Honor, that makes a declaration that says you cannot, that the debtor's conduct in this bankruptcy cannot be the basis of a coverage defense, and gives that, it's a declaratory judgment, Your Honor, in the confirmation order approving the plan. So that is what we are pointing to. The presence, the language in the plan itself, the courts don't look to what the plan says, Your Honor, they look to what the plan does to assess neutrality.
But just taking that a bit further, I mean, and I don't, hypothetically, if you were to say or offer an argument about that clause that no court has ever adopted and that was uniformly unreasonable, and please don't take that as suggesting that's what I'm thinking your position here. But if hypothetically a party did that and a court said, hey, this is just some way out there argument that no one's ever done before, it doesn't make any sense, and we got to dispose of it to move on with the plan, but everything else related to the insurance is still the same. Are you saying that makes, that defeats insurance neutrality? So whatever argument an insurer makes, even if it's outlandish, you automatically, because there's a ruling on that, lose neutrality?
No, Your Honor. Our argument focuses on this, like most insurance neutrality arguments, focuses on this particular plan and this particular confirmation order. And this particular confirmation order declares that the debtor's conduct in this proceeding cannot be the basis for a coverage defense based on the lack of cooperation. So that takes something we had before the plan was confirmed, the ability to assert that as a coverage defense, and it takes that away for us. Now, we can debate the merits of that, but not.
How is that going to come up? You're now back in a state or federal court. It's an asbestos case, and the bankruptcy court has said to Kaiser and whoever the other defendants are, all right, you have to cooperate. So you go into that case, you ask them to cooperate and give you information with respect to whoever the plaintiffs are in that case, and they say no. So you're going to have an affirmative defense in the state court, or you can go back into the bankruptcy court and get an order from the bankruptcy court, or have that exempted from the plan. I'm having a lot of difficulty understanding just what this right is you say you've lost.
What we lost was the right to assert as a coverage defense based on the debtor's conduct in this proceeding, that it did not cooperate with us.
It's supposed to be a defense in an actual asbestos case that's pending in the state court somewhere?
No, Your Honor, and it doesn't need to be, because our argument is that the language of the agreement, the insurance policy, it does say in the conduct of suits. That is the last item in a phrase in a sentence that follows three ands. So that is not the exclusive way that the duty of cooperate. The duty of cooperation is unqualified initially, just says is obligated to cooperate, comma, and then the clause goes on, and it ends by saying, and in the presentation and preservation of evidence, and in the conduct of suits, Your Honor.
But if as a matter of law, you didn't have that right that you claim you have to use this type of situation to say there's been a violation, so long as you still have the right to assert it on a case-by-case basis, would that be the case? Would it be neutral in that sense if you erroneously asserted that this clause entitles you to do this?
I think I understand your question, Your Honor, and I think that whether we can is a merits question and not a standing question. I think an insurance neutrality goes to, although it's not entirely clear in the case law, I think it's best understood as going to standing.
The basis of no stand, I mean, there's a whole bunch in that to unpack in that with standing in bankruptcy court. We could spend hours talking about Lexmark and what all that stuff means. But in order that the principle of insurance neutrality, there's got to be a determination that it's neutral or not. And so you're saying you cannot make, if the issue of whether you had that right to begin with essentially is irrelevant in the insurance neutrality discussion?
I wouldn't go so far as to say it's irrelevant, Your Honor. You could certainly imagine, I guess, cases of, a frivolous assertion, but that's certainly not what we have here. We are basing our argument on the plain text of the insurance policy, which obligates Kaiser to cooperate, comma, and then it goes on and then it explains more specific circumstances. But I think it is sufficient for standing, and it's sufficient to defeat insurance neutrality, both on the language on the coverage and also alternatively independently, as the Seventh Circuit held in one of my friend on the other side's own cases, C.P. Hall, that whereas here you have a situation where there is a scheme, an alliance between the debtor and the claimant that adversely affects the insurer, and I don't think there's any argument that since we are the party on the hook for paying for fraudulently inflated claims, that fits this case to a T regardless of insurance neutrality. So I think there are two ways for this court to resolve that issue. And of course, then our 520, our good faith arguments about why the plan wasn't proposed in good faith, I don't think any of that has to do with insurance neutrality at all, Your Honor. I think that is a separate and independent argument that we have proved up standing independently of that. And I see that my red light is on. If there are no further questions, I'll reserve the rest of my time for rebuttal. Thank you, Your Honors.
Thank you very much, Ms. Ho. You save some time. Mr. Marshall, tell us who you represent.
I represent the debtors. Good morning, Judge King. May it please the court. The only objection to the confirmed plan here comes from a primary asbestos insurer, even though the plan expressly preserves Truck's rights and the debtor's obligations under the Truck policies. Before the bankruptcy, Truck was obligated to defend about 14,000 asbestos claims, even fraudulent ones, with the cooperation and assistance of Kaiser and Hansen, the debtors, and then indemnify up to $500,000 per claim. After the bankruptcy, all of this remains the same for Truck. The lower courts, with the district court considering the matter de novo, both found that, and I quote, the plan returns Truck to the tort system exactly as it was pre-petition. It simply restores Truck to its position, and Truck loses nothing. Correspondingly, the plan enables nothing. It facilitates nothing. The debtor's excess insurers indemnify amounts exceeding that $500,000 limit in the Truck policies. None of them objects to the plan. So what Truck, unlike the excess insurers for the same claims is seeking, as both lower courts also found, is to use someone else's bankruptcy to improve its policies, to change them to its advantage, and to limit its financial exposure. And it's doing all that with no factual predicate in the record, but instead on claims that the lower courts found to involve speculation.
So, counsel, let me just, it's a little bit hard to navigate whether we're talking about merits and standing and all this sort of stuff. But, you know, the bankruptcy or the district court found that the situation here with respect to trust was insurance neutral. And it found that that Truck did not have, or to the extent there was a claim about, you know, failure to cooperate by, you know, your client's, you know, involvement in this plan, that didn't violate the duty to cooperate. I mean, I've said that perfectly, but those findings are basically there. Doesn't Truck have the right to appeal those two findings? Do you dispute that there's not standing for us to consider those issues on appeal?
We do dispute that. So as a matter of appellate standing, they don't have the right to.
But everybody loses in the federal court system has a right of appeal. 1291 gives every loser a right of appeal, does it not?
It creates
Truck lost. And if they lost, they have a right of appeal. I mean, I have trouble getting past that point.
1291 creates subject matter jurisdiction in this court for an appeal, but in the context of
It gives
bankruptcy,
appellate jurisdiction
yes.
for final decisions. And Truck presented these issues below to the bankruptcy court, to the district court, correct? And lost.
Yes.
And lost. I mean, the merits are a different thing, but I have trouble with the point that they don't have a right of appeal when we give everyone else that comes to this court, in any kind of case, the right of appeal.
We're not disputing jurisdiction, Judge King. Judge Quattlebaum was asking about standing or right to appeal.
But standing and jurisdiction, that's where it gets kind of. Are you basing this on this these prudential bankruptcy standing sort of things, or let's just break it down. Do they have Article III jurisdiction to appeal? Do they have Article III standing to appeal?
They have Article III standing to challenge whether the plan is insurance neutral.
And does that include the decision about the duty to cooperate?
That would be a part of that, yes.
Okay, all right. And your position is they don't have bankruptcy appellate standing under this person aggrieved concept and
Correct, under this
mootness?
court's precedents in urban broadcasting and Clark.
Okay, all right. I understand
That's
what
not
you're
a
saying.
jurisdictional doctrine.
Correct.
It's the way this court and every other court has interpreted the bankruptcy code.
And it may or may, and there's I got you, and I think the validity of that, is something that the parties dispute, or at least there's out there dispute about, in the wake of Lexmark. But at least I understand your position.
And no
on it.
court has repudiated the doctrine since Lexmark, and this court has applied it in
We've imported
unpublished decisions.
in unpublished decisions.
Yes.
So which parts of the appeal now that you say that there is no standing for? Because I'd understood you initially to say that Truck did not have standing, at least to be here, on the insurance neutrality issue, and then you just said that they do.
But as Judge Qualba mentions, the doctrine's titles are unhelpful sometimes, but I'm going with what the courts say. So if we're talking bankruptcy appellate standing, they don't have the right to be here at all. If we're talking what's often called bankruptcy standing, or I'll call 1109B, just so I don't have to say standing, they have the right to challenge whether the plan is insurance neutral.
But if they lost, which is the key factor as to them, you're saying they have no right to appeal that order.
Correct.
And that's because
The order does not directly affect their pecuniary interests. Their own theory of the case is not that the order itself causes a pecuniary harm. It's that in a later case, after the bankruptcy in the tort system, they might face a liability they would not otherwise have faced, or a larger one, depending on how discovery goes.
as a matter of law, if the plan was not insurance neutral, you say that does not affect Truck.
That does not give Truck appellate standing.
So
We don't deny that that would affect Truck in some
So they
sense.
could raise this issue in the bankruptcy court, lose, but even though it's erroneous, they couldn't appeal it.
Correct. And that's the urban broadcasting case. It's the opportunity finance case from the
So-
8th Circuit.
So let's assume it was not a duty to cooperate generally, that they were arguing in case Smith versus Kaiser in, state court in Greenville County, South Carolina, that Kaiser had violated its duty to cooperate. Let's assume hypothetically that was in there. The bankruptcy court said no. You don't, that there was no duty to cooperate, and they issue a finding there. Are you saying they can't appeal that?
Yes.
Okay, that's just something because it.
There are, in urban broadcasting, opportunity finance, Ernie Hereford, the party's allegation was they had lost a defense that they would be invoking in a subsequent litigation. The court said that's not direct. Or in the Marbow case from EDVA, which we cited.
Okay.
That's the doctrine of appellate standing, which recognizes the unique realities of bankruptcy litigation, which is usually a sprawling mess.
Now,
Yeah.
the order here was entered by the district court.
Correct. Truck received
Right.
de novo review in the district court, which is a little different from your typical bankruptcy case. So two courts of
Bankruptcy
independent.
judge made recommendations, basically,
Exactly.
but like a magistrate judge. We call those recommendations, but here I characterize them as recommendations. It went to the district judge. He actually had a 2 or 3 day hearing and
Correct.
took all these things up, and Truck presented them and lost, and you're saying he can't appeal.
Correct.
They can't appeal. Truck can't appeal. And that-
Truck cannot
that
appeal,
that
and I
just
refer the
runs-
court-
That just runs counter to everything that I've ever known about the process we have.
Bankruptcy is a strange world, Your Honor, but there are two precedents of this court, and I particularly refer you to the more recent one, urban
They're Article
broadcasting.
1 courts, they aren't even Article 3 courts. It's an Article 1, right?
I'm about to run out.
statutory court does things that are, what, here, millions of dollars, 14,000 lawsuits, impacting all these people. And it's unreviewable. And that's your position.
I see my time is up, Mayor.
But no, you go right
May I
ahead.
respond?
I'm just, I'm musing a little bit.
I will simply keep
You
pointing
can
you back to
respond to that.
the same three cases I mentioned, especially this.
No,
one.
and again, I mean,
And if,
you could be wrong on standing, we say yes, they have standing, and you could be wrong on this equitable mootness, we could say we're not going to dismiss it on equitable mootness, but you could be absolutely right on the merits, correct?
correct, and
Right.
when we say
And
merits,
you'd win the appeal,
yes,
and you'd go home happy.
I would not object to that, Your Honor, and I would refer you to the CP Hall case, which Ms. Ho also mentioned.
But you would say we have made a bunch of bad law.
Oh, I would not at all say that, Your Honor. I'm happy to have my client win on any ground you would wish to give us. I point you to the CP Hall case, and if you're inclined to look at the text of the Assistance and Cooperation Clause, I urge you to read it in context. It's J803. There's a provision about occurrences, a provision about claims, and then a provision about the cooperation. The whole context is individual claims. Ms. Ho recognized it's a standard clause, and so I refer you to the Admiral case, which addressed what these kind of standard clauses do. Thank you. If there are no further questions, I'll yield my time to my colleagues.
Thank you, Mr. Marshall. And Mr. McClay, it's your turn, sir. Good to have you with us.
Thank you, Your Honor. It's a pleasure to be here. I'm supposed to change the cover. Good morning, Your Honors. May it please the Court, I'm Kevin McClay, and I'm here representing the Official Committee of Asbestos Personal Injury Claimants for Kaiser Gypsum. Your Honors, it's important to note from the committee's perspective what a momentous accomplishment the debtors' successful confirmation of the plan below was. It required the debtors to successfully negotiate with their asbestos creditors, the representative of future claimants, state and federal environmental agencies, other unsecured creditors, and 12 insurance companies. But they did it, and they received 100% approval on their plan from all creditors entitled to vote. And this outcome was in keeping with the purposes of Section 524G of the Bankruptcy Code, which, as the Third Circuit has noted in Federal Mogul, is to protect the rights of asbestos claimants while also enabling asbestos defendant companies to obtain a bankruptcy fresh start. Indeed, there was only one objector to this plan, Truck Insurance Exchange, who objected even though the plan left Truck exactly where it was pre-petition, an insurance company defending and resolving asbestos personal injury claims against the debtors in the tort system, as it has done for decades and as it is continuing to do right now. But this behavior was no surprise, but it was the continuation of a long pattern by Truck of attempting to reduce its insurance obligations. As the Bankruptcy Court noted, we are here because decades ago, Truck improvidently wrote an unlimited insurance policy, and that Truck would like to improve that deal and use this case to limit its exposure. But, Your Honor, it's very fundamentally, the law does not give an insurance company a veto over a Section 524G plan of reorganization, whether pursuant to unsupported state law arguments or otherwise, and this court should reject Truck's objections to the plan. Now, Your Honors, I'd like to go into several of the issues that Your Honors have raised in previous questions, and I'm basically going to put aside most of my planned remarks because this is more pertinent, I think. First of all, Your Honor, fraud is a factual issue, and there was no evidence of fraud below. The record is absent of it. In fact, the Truck's experts didn't even look at a single claim file involving Kaiser Gypsum and had no knowledge of whether there was any disclosure or non-disclosure of other alternative asbestos exposures.
Well, as I read Truck's brief, which I may have read incorrectly, but as I read it, they seem to argue that if they were back in a state or federal court trying an asbestos case and wanted the information they sought in the plan as in terms of, has the plaintiff in this case gotten coverage from another trust? Is there some other nefarious activity going on that they're going to be prohibited or inhibited in some way of doing that? But I wasn't exactly sure how.
Well, I'm not exactly sure how either, Your Honor, because this is a pass-through plan. And what a pass-through plan does, it takes claims and it puts them back to where they were. It's a very common, typical concept in many bankruptcies, including in many asbestos bankruptcies. And Truck is back in the tort system just as they were before, with the same discovery protections, the same state law rights as they enjoyed before. To the extent that what Truck is saying is they don't like the state law regimes. They don't like what the state of Virginia has decided to do with respect to discovery. They're not entitled to change that legal regime. So even if they had a point, and they don't, as I'll get to in a second, that they don't get all the discovery they want in the state court system, that's a matter of state law. They don't have a right to change that because of a bankruptcy, and there's no legal doctrine that says that they do. But secondly, Your Honor, of course, it's also, in our view at least, not accurate. They have the same discovery rights as they have always had in the tort system to ask the plaintiffs whatever questions they want to ask about alternative exposures. The trust, in fact, do respond to subpoenas. As if you look at the trust distribution procedures, you'll see that that's the case. And so their claimed harm just doesn't exist. They have the same rights they've always had, and they're not entitled to more. But to going back to what I was saying a minute ago, Your Honors, fraud is factual, and the record is absent of any suggestions of fraud. I could talk more about the Garlock case, but suffice it to say it was subsequently mooted. It was interlocutory, and Judge Hodges was the original judge, but Judge Whitley took over the Garlock case. That's the same bankruptcy court judge in Kaiser Gypsum, the successor judge to Garlock. And yet he found their Garlock-based arguments extremely unpersuasive and rejected them as a matter of fact. And they have not shown that his ruling in that regard was clear error.
So, counsel, if I could try to just figure out a little bit of the, how this all fits together structurally. Mm-hmm. Let's assume, maybe a little bit like Judge King was talking about, that we agree with Truck that they have standing to appeal the decisions about insurance neutrality and the decisions of the district court about the cooperation clause. Mm-hmm. And we decide they can appeal those, and but we find that they lose on the merits of those. Mm-hmm. Where does that leave us with respect to the plan objections to the compliance with 524G? I mean, in other words, those are obviously connected, but first of all, you can have standing on some claims and not others, correct? Absolutely. And does our decision about whether Truck has insurance to object to the merits of compliance with the statute depend on whether we find against them on the issues that hypothetically we have standing, the neutrality issue?
No, Your Honors. No, Your Honor. They don't have standing to object under 524G's provisions, for example, because those provisions aren't for their benefit. Those provisions only affect the uninsured claimants that would collect monies under the trust. So as a matter of basic constitutional standing, they don't have standing to argue about someone else's rights. So regardless of your ruling on any other issue, they don't have standing to talk about 524G compliance. And all cases are uniform on that point. I don't think there's a single case that goes the other way.
Okay. So even if we say, switch my hypothetical, we have standing to consider insurance neutrality, and we say it wasn't neutral, they don't have standing to object to the compliance with 524?
If you say that the plan isn't insurance neutral, they still would not have standing to object to 524. That's correct. They would have standing to object about the interference with their rights.
Right.
But not as to 524G.
That's just not their business because it's there to protect uninsured creditors, is that?
That's exactly right. With respect to the insurance neutrality language, I'll just note another thing, Your Honors, which is that There are 12 insurance companies in this case, and 11 of them thought that insurance neutrality language was just fine. In fact, they negotiated it pursuant to an extensive plan negotiation process. It's just one insurance company, Truck, who didn't like it and didn't think it was actually neutral. There are a series of California state court cases, Your Honors, interpreting the duty of cooperation in individual cases, and none of them go the way Truck would have them go here. And the Admiral Insurance case mentioned by my colleague to my right, of course, also was expressly on point, saying cooperation clauses can't be used in this way. And Your Honors, I see that my time has expired. If Your Honors have any further questions.
Other questions?
Thank you.
Thank you very much, sir. We appreciate it. Mr. Herron?
Good morning, Your Honors. My name is Ed Herron. I have 3 minutes, so I will be succinct. I represent Lawrence Fitzpatrick. He was appointed by the bankruptcy court to be what we refer to as the future claimants representative. That was on motion of the debtors with the support of the committee. The appointment of a future claimants representative is an integral component of 524G, and really part and parcel to 524G's focus on protecting the interest of future claimants. And of course, because asbestos has a long latency period, there are claimants who will come forward to seek compensation from their exposure to Kaiser's products who don't yet know they're sick. So the future claimants representative stands in for those claimants. And really we see our role as twofold. To ensure that whatever funds go into a trust are sufficient to compensate those future claimants, and then to make sure the trust is structured and administered in a way that money remains for future claimants. And here, Mr. Fitzpatrick is highly experienced in this role. He's been appointed in 11 cases, including this one, in 6 different jurisdictions. And we're here to assure Your Honors that this plan does fulfill a very important purpose and satisfies the requirements of 524G. We participated in the negotiations and the diligence that led to the plan, and we are one of the, we supported its confirmation. And we believe that the trust, as funded with $50 million, $49 million in cash and $1 million in a note, is adequate to protect the interest of future claimants, and really those interests are kind of twofold. The way the trust works is it fills the gap where the company would otherwise pay a deductible. In the early years of the coverage, the deductible is $5,000. In the late years, $50,000. And then there are some periods later in time where there is no coverage at all, and the trust would pay those uninsured claims. Because future claims come last, they're more likely to be susceptible to the risk of a higher deductible or no insurance at all, and the trust fills these holes. Now, one might say, well, without the bankruptcy, Kaiser would be there to pay the claims not covered by insurance. But I wanted to remind Your Honors that before the bankruptcy, Kaiser was being subject to punitive damages awards, which are not covered by insurance.
Not very many.
3 of the last 7, Your Honor, which one included a $20 million punitive damages award. So if that trend continued and Kaiser were rendered unable to pay or had to go into a Chapter 7, our constituents would be the ones who are most harmed. Of course, in a Chapter 7, who knows how the insurance is administered? Who can say whether anyone at all would be around to satisfy the cooperation clause? And then we'd hear a bunch of other reasons why Truck can't pay. But this benefit didn't come for free. It's at a cost to claimants. Significantly, current and future claimants have given up the right to seek punitive damages in the trust and in the tort system. Right there, that benefits Truck because obviously they're not facing punitive damages. The plaintiff's leverage to settle their claims in the tort system goes down. Truck's already been benefited here. What we're talking about is whether Truck should receive an additional benefit and whether they have essentially a veto in this case to leverage that benefit. I see I'm out of time, Your Honor. We're already into the 3 minutes. I would just like to make one observation about the standing argument. And that is, were this court to find that Truck has standing on these facts, where its legal argument on the cooperation clause, it is frivolous. And the district court found that it was contrary to all notions of insurance policy interpretation. And their factual arguments of fraud are supported by zero evidence. So if Truck is granted standing to challenge any component of this plan, any insurer in every bankruptcy case will have that same standing, because they have shown absolutely no harm at all. Thank you, Your Honor, unless you have questions.
Thank you very much, sir. Good to have you here.
Thank you.
Ms. Ho?
Thank you, Your Honors. I've got a lot to shoot at. I'm just going to make 3 basic points. First, let me address the points my friends on the other side have made and the panel has questioned me about the duty of cooperation. I heard my friend, representative for the debtor, refer to the Admiral insurance case. As we explain on page 17 of our brief, that case involved a cooperation clause that was explicitly limited by its term to suits. The language of that clause read, insured must cooperate with insurer in the investigation or settlement of the claim or defense against the suit. That is not the language that we have now. We also, on page 26 of our opening brief, cite a case called Congolium, where a New Jersey court held that a collusive settlement of asbestos claims in a 524G bankruptcy violated the insurance cooperation and good faith obligation. Point 2, I heard my friends on the other side say that there is no evidence of fraud, no factual predicate, I think was the phrase used. Let me refer the panel to JA 5195 through 96, where one of our experts identified fraud against Kaiser by examining 205 Kaiser claims that overlap with Garlock claims for which discovery was available. And he found that in those cases against Kaiser, plaintiffs omitted 63% of their asbestos exposures in tort discovery. Our other expert testified, and this is at JA 5271.
Fraud allegations as to what you call the plaintiff's bar? Is that who you claim is the fraudsters?
I am not making, I'm not going to make an allegation fraud. I'm just saying, yes, that there was widespread evidence suppression, just like there was in Garlock
the plaintiff's bar.
here.
I mean, you all seem to go after the plaintiff's bar, what you call the plaintiff's bar.
I'm not, Your Honor, I'm not going after him. I'm just talking about the evidence of evidence suppression in these cases. So it's
You said
simply,
that you characterize that as fraud.
yes, Your Honor, I
You
did.
said your expert said it was fraud.
Yes. At a minimum, litigation
suppression.
abuse, Your Honor, yes.
It was fraud, but I'm just trying to see who the fraudsters you claim are, and I assume that you're talking about the lawyers.
Correct.
Yes.
Correct, Your Honor, yes.
That's what you call in your brief, the plaintiff's bar.
Yes,
A small p and a small b.
yes, and several firms that were involved in the Garlock claims found to have involved evidence suppression are also on the committee here. So there is overlap. So it wasn't mere speculation, Your Honors, about the fraud that was discovered. Yes, Your Honor.
But you know, I actually used to deal with claims. So, I mean, it's pretty normal to send some discovery request and ask a bunch of information about exposure and things like that and other causes and damages. And, and if people don't respond honestly, there's severe consequences under Rule 37 sanctions. I mean, I know you're very familiar with all that sort of stuff. Those are there in every case. Why is that not enough for you? Is there some thought that the rules don't allow discovery into this, or that just Yeah, I'm not understanding why rules that I'm pretty familiar with don't give you the very protection you need.
Two responses to that, Your Honor, and let me actually focus on another major source of the litigation of abuse or fraud that was uncovered, and that is the pattern of claimants who, after they're in the tort system, then go to trusts, different trusts, and make a variety of claims based on exposures that were not revealed in the trial court. So the trial courts can do nothing. They don't have the tools to do anything about that litigation abuse, and that's an entirely separate problem from the evidence suppression. And respectfully, Your Honor, that's just what the Garlock evidence disclosed, is that in these tort system claims, when claimants said how many exposures, they were simply not claiming the number of exposures that later came to light that they had presented to trust. So I think the state court simply don't have the tools to deal with that prong of litigation abuse. But I think in the main point, Your Honors, there was a factual predicate. Let me also respond on really briefly on the insurance neutrality point, if I may, Your Honors.
You go right ahead.
Thank you, Your Honors. Again, I think the key thing there, why this plan is not insurance neutral, is that the order itself approving the plan takes a coverage defense that we asserted as to this proceeding. So this is not speculative about some future proceeding, about this proceeding, and the district court resolved that question against us. Judge King, as you said, we lost on that issue. So the plan is not insurance neutral, and at a minimum, we have the ability to challenge that on appeal. My last point, to your series of questions, Judge Quattlebaum, about 524 and our standing to make that point, we take the statute at its word that a party in interest has standing to be heard on all issues. But even if we're wrong about that, at a minimum, we would have standing to challenge, set aside the 524G compliance. It's a separate argument that the plan does not comport with good faith, with the good faith requirement. That's a separate and alternative basis than the 524G. And for both the insurance neutrality issue and the good faith issue that we've raised and that we believe we have standing to raise, the remedy that we're seeking is the same. That this court would remand with instructions. It's a limited remedy for the district court below to include the same anti-fraud provisions that apply in this trust to the uninsured claims that the trust is responsible for. And I do have to respectfully correct or alter something that I believe I heard one of my friends say on the other side about that somehow claimants can no longer seek punitive damages. I'm not aware of any support for that. And the one punitive damages that was awarded, I think I heard 20 million. That's 1 in 38,000 claims, and that was later cut down to just under 4 million on appeal. So we think we have standing across the board. We think at a minimum this court can remand with instructions for the district court simply to add the same basic fraud protections that are in the plan that apply to uninsured claims for which the trust is responsible for, and apply those same protections to the insured claims that we are responsible for. There are no further questions.
Thank you, Ms.
Thank you.
We appreciate
Thank
it
you.
very much. And I'll say again what we mentioned earlier in the first case. We normally, this court, arise from the bench now and come down and re-counsel. And tell you, we're happy to have you here and compliment you on the hard work that you've done in this case, and we know that you all have done in this case. And we really appreciate it, and we appreciate good lawyering, and we're glad to have you here. And next time you come, we'll shake hands with you. And with that, Madam Clerk, we will take a brief recess and we'll reconstitute the panel.
This honorable court will take a brief recess.
Thank you, Your Honor.
Be seated. I welcome you to the Fourth Circuit today, and we have had a break, and this is a new panel consisting of Judge Quattlebaum and me, and we're welcoming Judge Hannah Locke of the District Court for Eastern Virginia, who's sitting by designation in connection with this case. And we really appreciate having you with us, Judge
My
Locke.
privilege, thank you.
This is number 21-1632, the United States trustee versus Darren Thomas Delafield. And Mr. Delafield, good to have you with us, sir, and be pleased to hear from you.
Yes, Your Honor. Darren, excuse me, may it please the court. I'm Darren Delafield, the appellant in this matter. Let me start with a couple of housekeeping matters. My right eye will drift off on me, so if I fail to make eye contact with you, I promise you, no insult is intended. Also, there's an error in my brief and in the U.S. trustee's brief. We both state that the U.S. trustee moved for a 45-day extension to object to discharge. In fact, the extension was for a 75-day extension. So the extension ended on May 31st, the same day that the adversary proceeding was filed in this case. I think that was harmless error, but just in case that fact was important to the court, I wanted to point that error out. In this case, the trial court relied upon erroneous findings of fact and false premises and violated fundamentals of due process, despite the guidance set forth in this court's opinion in the case of Nell versus U.S. According to Nell, due process requires that disbarment or suspension proceedings be preceded by advance notice and an opportunity to prepare a defense. Those prerequisites were not met in Nell, and they were not met in this case. The erroneous findings of fact of the bankruptcy court can be traced directly to the failure to give advance notice and an opportunity to prepare a defense. The Fourth Circuit in Nell recognized that the lack of due process increases the risk of error by the trial court. Due process protects not only the accused, it protects the trial court from error. Excuse me. The lack of advance notice, as the court held in Nell, is constitutionally inadequate to provide a foundation for the extreme sanction from the disbarment from the practice of law. When you don't create that foundation, you then create a risk of error and a risk of harm to all of the parties involved. The bankruptcy court was never given advance notice by the U.S. trustee that it would be asserting new theories at trial. The bankruptcy court thus did not know which facts to focus on and lacked context when ruling on trial motions.
So, counsel, can I, it sounds like the position you're asserting is not that the remedy that was awarded was that there was not that there was no notice of that, but that there was no notice of some of the grounds for which the remedy was awarded.
That's correct. The complaint that initiated the adversary proceeding clearly said that I was at risk of receiving a $5,000 monetary sanction, and clearly said that I was at risk of being disbarred or otherwise sanctioned. And if I did the things that I'm accused of, I forged debtor signatures, right, or I asserted attorney-client privilege in bad faith, or I blocked my clients from getting a discharge, those remedies would likely be appropriate. In fact, I'd probably be pleased to walk away with only that as a sanction, if I had done those things. In this case, the attorney-client privilege was
the complaint was filed against you and others and law firm and that you were part of or whatever you were in Chicago or someplace.
That's correct.
It was filed by the United States trustee.
That's correct. The complaint was initiated by a complaint from the U.S. trustee's office.
And you're saying that complaint is not sufficient to comply with the due process notice requirements required under Nell.
That's correct. I think
is it fair to say that nobody involved in the bankruptcy court had ever heard of the Nell case?
It seems that, yes, that neither the bankruptcy court, nor the district court, nor the U.S. Trustee's office, nor myself were aware of Nell versus U.S.
And you didn't know about it until the court, our court, forwarded it to you and the U.S. trustee. Is that right? You briefed this case. You briefed this case without knowing anything about that case.
That is absolutely correct.
But now you looked at it and you know that it was published in 1971 and written by the chief judge of the Fourth Circuit Court of Appeals and concurred in by two other judges, I think Judge Craven and Judge Bryan. You know that now, don't you?
I do, Your Honor, yes. Yeah.
And you say it has something to do with this case. Maybe the trustee may say it doesn't have anything to do with it. But it's kind of shocking to me that if it does have something to do with it, that nobody knew anything about it. It's in the law books. It's in the Fed, I think it's in the Fed Second somewhere.
I believe that's correct, Your Honor.
Right.
And
you let the court do your research for you.
And I am humbly grateful for the court doing that for me, Your Honor. While the issue of due process, I think, has been litigated.
But Judge Hainsworth, who was who lived down where our friend Judge Quattlebaum's from, I think his name may be on Judge Quattlebaum's courthouse.
See it every morning.
He's a renowned chief judge of this court for 30 years. Did you know that?
I did not, Your Honor. So
You didn't look him up after you got a hold of that opinion? He was really the fella. That's right.
yes, Your Honor.
And did you see who the losing lawyer was in that case?
I did. I believe he's now a Fourth Circuit judge, Your Honor. I believe it was yourself, Your Honor. The facts in that case are eerily similar to the facts in this case, loosely, in that a Florida attorney came to West Virginia and then consulted with local counsel. And unfortunately, although I've not had a chance to interview Attorney Wood, who was the local counsel in West Virginia in that case, it appears that he was misled by counsel from Florida, and that without any advance notice, other than the fact that the judge was going to have a hearing to reopen the case, decided sua sponte to sanction both the Florida attorney and Attorney Wood in that case without giving them advance notice or the ability to hire legal counsel or otherwise prepare a defense.
Go ahead, Judge Locke.
Did Mr. Wood have a 4-day trial?
He did not have a 4-day trial.
Was there any complaint filed against him that gave notice at least of a remedy?
No, other than the fact that I believe the opinion says that he was told that there was going to be a motion to reopen and that their conduct was at issue, but there wasn't a specific set of charges. And that's my complaint in this case. The complaint as filed by the U.S. Trustee's Office, characterized loosely, is that I should be held per se liable under some sort of strict liability standard for the conduct that occurred in Chicago by the Upright Law Firm. And if the finding of the bankruptcy court was limited to that factual allegation, I think I would still be here on appeal arguing that local counsel can't be held strictly liable absent a failure to implement reasonable measures to ensure that attorneys and paralegal staff are supervised. But not chasing that rabbit, what I'm complaining about is that it's extremely difficult to defend yourself against new charges asserted for the first time at trial.
But you knew before the trial started, didn't you, about the specifics?
No, I would disagree with that characterization, Your Honor. There was an answer to an interrogatory that was provided to myself, but that interrogatory, or the answer to even to that interrogatory, did not fully set forth the theory of the U.S. Trustee's Office as it was advocated.
Make a motion for, and we used to be in the, I guess we still have them on the books, in the criminal law, you could ask for a bill of particulars as to an indictment. You didn't ask for anything like that?
There were no advance.
They didn't take your deposition or anything?
We attempted to take the deposition of the U.S. trustee.
You
and
did, but did they ever attempt to take your deposition?
They did take my deposition, Your Honor.
They
yes.
did, okay.
Yes. Yeah, and in fact, one of the new allegations that is raised against me is that I was somehow dishonest in my answers to responses I gave at that deposition.
So, counsel, the adversary complaint, contains a good bit of detail about the, I guess, a Sparrow program. I don't know if I'm pronouncing it right. But
I prefer to call it the new car custody program to avoid the use of Sparrow.
right,
So-
well, but it contains a good deal of information about that and how that's maybe at the heart of the complaints against you. I mean, do you agree with that?
I do agree with that.
Okay.
I think a fair characterization of the original complaint as originally filed is that I should be responsible for my clients having participated in the new car custody program because I in some way ratified their participation, or that I should be held strictly liable because they participated in the program and then ultimately chose to file a bankruptcy petition on their behalf.
So if you were aware of what you just said, plus the fact that they were seeking the monetary penalty or the fine and the 1-year suspension, I recognize you've identified perhaps some areas that weren't specifically listed in the adversary complaint. But, if you had that information about the Sparrow program, I think that was the basis of counts 1 and 2 and 3, the disgorgement findings. And then the findings about the fine and the suspension, the Sparrow or the car custody program, whatever, was a substantial part of that finding too. Do you agree with that?
I'm not sure that I followed your question. I do.
Let me just try to do it this way. I mean, I guess my point is, it sounds like you concede you had notice of the, complaints against you concerning the car program. And if that's true, and there were, 1 or 2 other complaints that weren't identified in the complaint, is it your position that the fact that there were some additional complaints nullifies the things that you did have notice of?
Yes, Your Honor, I think so. I think once the trial court made erroneous findings of fact and allowed the U.S. trustee to assert new theories after the deadline had passed to amend the complaint,
Was that specifically done? Was that specifically done?
Was what specifically done, Your Honor?
That the court allowed the additional theories after the time for amendment had passed?
Yes, Your Honor, I would argue.
Was it done by implication or done explicitly?
No, by implication.
By implication, that's what all right, it just happened.
Yeah, at trial.
It just happened at the trial.
At trial, the U.S. trustee began to introduce evidence regarding
No notice before the trial, no pretrial order or anything that specified any of these new allegations.
There was a pretrial order that set a deadline to amend the complaint, but the complaint was never amended.
Right. Anything is by implication.
That's correct. So
failure to do it, basically, I don't want to put words in the trustee's mouth, they're basically now saying harmless error. Or so what?
Yeah, I see that I'm out of time.
You keep answering questions as long as we ask them.
Yes, Your Honor. Yeah. Yes, so during the 4-day trial, the U.S. trustee attempted to introduce evidence regarding the discovery dispute. My counsel objected to that evidence. The U.S. trustee responded that the evidence should be admitted for the limited purposes of rebutting any theory that I might assert that I had reformed behavior. So that is, I think, clearly set forth in the record. Then, in the closing written argument, the U.S. Trustee's Office asserted new theories in its written closing argument. In my reply, in its closing argument, in my reply brief, the very first opportunity I had to respond, on page 68, I specifically objected to those new theories which were being asserted as part of counts 4 and 5. Ultimately, the court did dismiss counts 4 and 5. So I do expect them to argue that, yes, it was harmless error because the bankruptcy court dismissed counts 4 and 5. But if you read the U.S. Trustee's brief before this court, even now, in front of this court, the U.S. Trustee is attempting to re-argue cases it lost below, or theories that it lost below, Your Honor.
Arguing the theories from counts 4 and 5?
That's correct, Your Honor, yes.
Okay. You've saved some time, Mr. Delafield. Let's hear from the trustee. Ms. Sakata?
Yes, Your Honor. May it please the court, Sumi Sakata for the United States Trustee. Your Honor, as Judge King anticipated, the United States Trustee does not think that Nell versus the United States have much relevance in these cases.
It's not relevant?
We don't believe so, Your Honor. Not to the extent that the difference of facts involved. As Judge Locke mentioned, there was no complaint filed in Nell. By contrast, here there was formal notice.
Well, and the thing was vacated. I mean, Nell was not the person subject to this. That's the name of the case. The lawyer's name is John Wood. But there was no complaint filed against John Wood. And that's part of the reason that the court granted Mr. Wood, this court granted Mr. Wood, Judge Hainsworth's opinion, granted him relief. Says you can't do this. He didn't get his due process rights.
Correct.
Because there was no complaint filed. That's right.
Whereas here there wasn't.
And here you filed a complaint.
Correct, Your Honor. Yes.
That's right. In Wood, it's a distinction. There is a distinction there. There's no question about it. And Wood got relief, and as you now know. But it does say that when you're trying to get sanctions, or it indicates you're trying to get sanctions against a lawyer, a member of the bar, the lawyer's entitled to notice specification of the charges, what they call it in the military system, and we call it in the criminal law system, they call it indictments and that kind of thing. But in complaints, they're entitled to notice. Due process requires that lawyers get notice before they get punished. And the question is whether that was complied with here, certainly, and that was the question before you knew anything about the Nell case. But the Nell case gives you some idea, or did, I hope, that that's been the law in the Fourth Circuit for a long time. But for some reason, none of the lawyers knew it. So Mr. Delafield is being accused of being an ineffective or unethical lawyer, but on both sides, nobody understood the law of the Fourth Circuit.
Your Honor, among other things, Mr. Delafield never complained about due process violations until this appeal. Even within the post-trial briefing that the court extended, he did not complain about the surprise of any new charges that were brought against him, in part because, as his counsel conceded, they were provided notice. The complaint that was filed alleged that Mr. Delafield and his co-defendants had engaged in illegal and or unethical behavior with regard to the Williams's case. And as Mr. Delafield conceded, in written discovery responses, in written responses to deposition questions, they had a question that specifically asked us to give the facts supporting what we contended was illegal and unethical behavior. And those responses included things like Mr. Delafield's inappropriate handling of his conflict of interest with the Williams. It included his assertion of the attorney-client privilege when the Williamses had not authorized to do so. It included also holding him responsible for the unauthorized practice of law in Chicago because he was a partner of Upright. So all of those items were included, as well as, frankly, his misleading bankruptcy pleadings that he filed on the Williams' behalf with regard to their car. So all of those were provided before trial started.
It's your position that the lawyers in Chicago and the lawyers in Virginia were responsible for everything that each of them did by normal agency rules, right?
That's part of our theory, Your Honor. It's not the only one.
And that would be quite a rule to apply to these big firms with their names on the buildings around here that have offices in New York and different places.
If those entities, even the most venerable ones, if they were engaging in the kind of inappropriate mishandling of clients, then yes, they should be, Your Honor. Should they not? But also, and this goes to where...
Are there any allegations in the complaint that specified the rules of professional conduct, the code of professional conduct, that were violated? The specific provisions of the code of professional conduct that were allegedly being violated. Did you make any allegations about that?
It was not specific to the rules. It said illegal and ethical conduct, Your Honor.
Pardon?
The complaint specified illegal and ethical conduct. It did not specify.
Legal and ethical conduct, but you didn't give any rules or statutes identify.
Not in the complaint.
And you did not identify in particular any rules of the code of professional, any provisions of the code of professional conduct that's applicable to lawyers in Virginia.
We did not specify that in the complaint. That's correct, Your Honor. But he was given notice of the conduct for which he was going, we contended he should be disciplined, and those...
Do you think that he knew all about it by implication? Which rules he was, what he'd done wrong? He knew by implication what was going to be tried?
To the extent they...
Implied notice?
Certainly as
I mean, you're arguing that he got due process.
Yes, Your Honor.
But it's by implied notice?
By notice of the grounds, the actions and inactions that he took in the Williams' case, that was unethical behavior and did violate his professional responsible duties.
But was sufficient notice, is that what you're saying?
Yes, Your Honor. As an attorney who's barred in Virginia.
And then the alternative, if it's harmless error, because he's guilty anyway?
He hasn't shown how...
He used to call that, well, I had a judge that I knew pretty well that used to sometimes refer to, in the criminal cases, the clearly guilty rule.
Your Honor...
Are you arguing the clearly guilty rule?
I'm arguing that he hasn't shown a prejudicial effect. If he has not shown in any way how he would have acted differently had he been provided with more advance notice. There's Mr. Delafield referenced In re Ruffalo in his reply brief for the first time. Had we had a chance to file a reply brief, we would have pointed out that the facts of Ruffalo, which contended that a defendant an attorney should know before the proceedings start what the charges are, but in a subsequent Supreme Court case called Zouderer versus Office of Disciplinary Counsel, which is reported at 471 U.S. 626, pin site 655, footnote 18. The Supreme Court explained that the Ruffalo has to be confined to the facts of that case because in that case there were, there was a new charge that arose after he had done his defense. And it arose from the evidence that the attorney had submitted in his defense. And the Supreme Court said that was prejudicial, but that in Zouderer, where the theory of the disciplinary grounds had changed from the time of the complaint before it was submitted to the trial, that was okay because there was no prejudice that resulted as a change of the theory. And although we maintain that Mr. Delafield was provided with sufficient notice of the grounds, he's not shown any how he would have acted any differently, what additional evidence he might have been able to submit had he been provided with more advance notice.
So, counsel, it sounds like, unlike in the Nell case, you would point to the fact that there's a adversary complaint that contained a good deal of factual information, contained a good deal of information about the relief or penalties that would be sought. And, through that and discovery, most, at least of the factual subject matter was provided in advance. You may not have identified the specific rules of professional responsibility, but you provided sufficient information that a counseled litigant would be on notice to what was presented and what they were facing.
Yes, Your Honor, absolutely.
So can I ask, so are you saying that in order to show prejudice, that Mr. Delafield would have been required to make some kind of offer of proof? Are you saying that he would have had some standard which he would have had to meet that he didn't?
Not necessarily a standard, Your Honor, but he simply hasn't made any attempt to do so. I mean, you do need to show some prejudice for there to be a due process violation. And one other point with regard to Nell and due process, Your Honor, is in Nell,
Now, the burden was on you, was it not? You filed the complaint. The burden was on the United States trustee,
Yes, Your Honor.
the burden of proof.
And-
But you're talking about what he didn't do.
On appeal, to have an appeal
At what
reversed.
point did that burden flip over? When did the burden switch then?
Your Honor, if he's trying to show a due process violation to reverse an order on appeal, the burden to reverse that is on him. We met our burden of proof, Your Honor. And the bankruptcy court, which held a 4-day trial.
You had the burden to carry the day and make a prima facie case.
Which we did, Your Honor, as the bankruptcy court found.
Without making charges.
We did make charges, Your Honor. We made specific charges. Again, the charges were given, he was given notice before trial started. He was also given general notice of the fact that we were maintaining he had conducted himself in an illegal and unethical manner in the case, and the bankruptcy court agreed with us. It was supported by evidence. The record firmly supports those findings. But again, I was going to reference Nell with regard to due process. If this court were to determine that there had not been sufficient due process, I would distinguish this case from Nell in an additional way, which is in Nell.
Are there any other cases in the Fourth Circuit since Nell about this kind of stuff? I mean, I haven't done a lot of research myself. Didn't do any research to find Nell, hardly. But I must have done more than anybody else did here.
Well, we did review Liotti and Lewis, Your Honor. Those were both cases in which, courts had suspended attorneys for misconduct and held it was within.
Before you had this hearing, you hadn't done much research because you didn't amend the complaint. And Nell, in the Nell case, another thing, nobody's mentioned here this morning, in the Nell case, Judge Hainsworth's opinion, this court ruled that for the punishment aspect, which would later, it would have to go to a different judge.
Your Honor, again, in Nell, there was no complaint. There was only a motion. And second,
No, there was no complaint. It's right. It was a summary thing.
Whereas here, there was a full complaint.
Thing. But the court ordered that the case be assigned to a new judge. So the judge hearing the case and resolving the case and imposing the sanctions, if any, would not be the judge who was offended, who in that case had been lied to.
Yes, Your Honor, although that was with regard to the outside counsel, not local counsel.
How would that apply here? The new judge requirement. How does that apply to this case?
Because in Nell, they held that because the local counsel had already had his practice privileges suspended, that there was no need for a remand. Whereas here, because the bankruptcy court made its order effective only once the order became final and unappealable, Mr. Delafield's practice privileges have never been suspended.
For a new judge. I don't have it in front of me, but I thought my recollection of the case is the last part of it, he says it has to go to a different judge.
That's, I believe, with regard to the, either the outside counsel or with regard to the criminal defendant. It was not with regard to.
Well,
the
the one
local counsel.
the criminal defendant, no, that was Mr. Nell. He wanted his conviction, he wanted a writ of coram nobis. And he got his writ of coram nobis.
But
that vacated his conviction. But and there were two lawyers. There was one in Florida, and he was held in contempt and fined. And he was not the one on appeal in Richmond. That was the West Virginia lawyer, the local lawyer. And he got a new judge at the end of it from Judge Hainsworth.
Respectfully, Judge King, I'm afraid I disagree. I think the way I read it was there was the government had moved to reopen the case. And that was the lack of complaint that reopened the proceedings. And there were two appeals, I believe, going on. And I believe that in now, Mr. Woods did not have a remand.
I didn't say he had a remand. I'm saying he had to get a new judge. I think it says at the end of the opinion. Maybe what's the end of the opinion say?
So, it's as to Nell's appeal, the reopening of the judgment in his favor pursuant to the motion under Federal Civil Procedure 60 did not operate as a final judgment adverse to him. His case remains pending in the district court. The order under Rule 60 was an interlocutory one from which no appeal may now be taken. And we should add that the outrageous conduct of Veron on Nell's behalf seems to be the sort of personal affront to the child judge that the Supreme Court has held should require the entry of a different judge in the case. And so it's with regard, new judge for Mr. Nell, the criminal defendant.
So the judge before Wood initially went out of the case.
For Mr. Nell.
Pursuant to this. That was
Yes.
Judge Christie.
Yes, Your Honor. But,
He was no longer in the Nell case. But here, you had the same judge all the way through. The judge that heard I think, the trial, made the findings and imposed the punishment.
yes, Your Honor.
All right. Would that be contrary to Nell?
So I'm trying to distinguish it in the sense that were this court to find due process.
Would that be contrary to Nell?
No, Your Honor. I'm saying.
Well, you had the same judge.
Yes, Your Honor. I'm saying if there's a due process violation, it should be
remanded. And in the Nell case, they got a new judge.
But they didn't remand it, Your Honor. Mr.
Well,
Woods.
they didn't have to remand it. They didn't have to remand anything.
No, I understand.
They were just dealing with Mr. Woods' handling of the thing. I mean, as you said, there wasn't any complaint filed against him.
Correct, but there was here.
But he said he's entitled to a new judge.
No, Your Honor, that was, again, the criminal defendant who's, oh, no, I'm sorry.
No, that wasn't Nell. Nell wasn't appealing anything. He got a writ of coram nobis. What was down there was, what was argued in the Fourth Circuit was the John Wood case. But
Your
it was
Honor,
part of the Nell case. The U.S. versus Nell was in 1932. And Mr. Nell was convicted of violating the Mann Act. In 1971, he filed a petition for habeas, for coram nobis. And you file a coram nobis petition in the same criminal case, the same case. So he filed a petition for coram nobis, which he was awarded. But that's where the lawyers lied to the judge.
Yes, Your Honor.
And so everything that happened after Mr. Nell got his writ was solely related to the lawyers. They lied to the judge, but the judge didn't bother the coram nobis writ. And they took the appeal to the Fourth Circuit. And I was the assistant U.S. attorney that tried to deal with it and lost. So I remember pretty much what happened.
Yes, Your Honor.
It's been a long time, but I still remember it very vividly.
Just, were there any due process violations in this case? We would simply ask that.
I thought there were two things that were potentially significant for you all that you didn't know anything about. One was the lack of notice, possibly, with the conclusory complaint, and whether the implied notice was enough. And I assume that's what you would argue, or that it's harmless error, which is basically what you're arguing. And whether the same judge who was offended, before whom these alleged allegations occurred, should be the one imposing punishment. But nobody's raised that really yet, which was raised and dealt with by Judge Hainsworth on his own, as you just read, with the concurrence of his two colleagues. It goes to a different judge.
As Your Honor mentioned, no one has raised that issue, and I don't think it should be at issue.
Pardon?
As Your Honor mentioned, no one has raised that issue here.
Counsel, isn't one of the issues there that, I mean, as Judge King's pointed out, and, I mean, there were, the judge was lied to, so that was a situation that was very specific where that judge had been the offending, jurist involved. And the conduct, as I understand it, that's alleged here wasn't the same type of conduct.
Correct, Your
of
Honor.
lying to the judge. So while it may have been under the auspices of the bankruptcy court and then the district court, there wasn't the type of personal affront to the judge that we had in the case involving Nell. Maybe there still should be if it goes back to a different judge, but it doesn't seems like we're talking about things that aren't exactly the same.
Yes, Your Honor, I agree with that. Thank you. But again, just to raise the point, if there is a due process concern, it's not a basis for reversal here, Your Honor. It's simply for vacatur and remand for further proceedings if there are, in fact, due process concerns. That's all, Your Honor. I see I'm out of time. Does the panel have any other questions for me?
Anything else?
Thank you, Your Honor.
Thank you very much. We appreciate you. Mr. Delafield?
I do have a little bit of reply. I'd like to start by drawing the court's attention to an unpublished opinion from the Fourth Circuit, and that's the case of Cohen versus Fox, and specifically read from that opinion. The Fourth Circuit, in the Fox opinion, held, but the importance of professional and financial interests at stake and the principles of due process mandate great caution before assuming the court knows all it needs to know and the respondent has nothing to add. Stating that I have nothing to add is a very bold statement. I would point out that if this case was remanded, that I might want to take the deposition of the debtor's father, whom they testified that they spoke to with about the new car custody program. I might want to take the deposition of the Chapter 7 trustee who presided over the 341 meeting. I might want to get different legal counsel who doesn't have a possible apparent conflict of interest between me and my co-defendants. To say that there's no error is very presumptuous because we don't know that the trial court, the bankruptcy court, knew all that it needed to know. The other reason I point to that unpublished opinion is in that case, the opposing counsel, Cohen, alleged that Attorney Fox was given all the due process he was required because he was allowed to file a brief. And this court rejected that argument that a post-trial briefing somehow satisfied the minimum requirements of due process. So although it's an unpublished opinion, I think it's worthy of the court to look at. I'd also draw the court's attention to the very last sentence of the U.S. trustee's brief before this court, and I'm going to paraphrase it slightly, but, quote, temporarily revoking Mr. Delafield's privilege to practice before the bankruptcy court causes him and others, close quote, to rethink, quote, associating with a national law firm, close quote. That's really what the U.S. trustee's office is upset about. They don't like national bankruptcy law firms, and they've admitted as much in their brief. Regarding, I guess, the possible remand to the bankruptcy court and whether a new judge should be assigned, I would have a couple of responses. One is the U.S. trustee's office has not argued a compelling reason why the case should be reopened to allow them to amend the complaint. Judge Black, the bankruptcy judge, set a deadline to amend the complaint. That deadline passed, and there's just no compelling reason to allow them, there's no issue of justice to allow them to come back and amend the complaint at this late date, roughly 7 years later. This process started in 2015. Memories have faded, witnesses have moved, and without some compelling reason, I would oppose that remedy on that basis. But I would also draw the court's attention, unfortunately, to Judge Black's statement when it was remanded by Judge Urbanski from the district court back to the bankruptcy court. Judge Black said regarding the sanction he imposed on a non-lawyer, Mr. Ed Scanlon, that if he had just had it, again, I'm paraphrasing, if he just had a chance to write a little bit more after having written all the pages that he did, that he should have put, and this is close to a quote, should have put more on the record regarding Mr. Scanlon. But it wasn't the judge's obligation to prove the case, it was the U.S. trustee's obligation to prove the case against Mr. Ed Scanlon. And they had a chance to do that. They had a 4-day trial in front of the bankruptcy court, and then they had an appeal in front of the district court, and the district court reversed that sanction against Mr. Scanlon. I think in part because the district court didn't like the fact that the finding of the bankruptcy court was that Mr. Scanlon's hands were, quote, never far from the wheel. And that rhetoric wasn't enough to meet the burden of proof. And I'm almost out of time, so I'll answer any questions that perhaps the court has.
Thanks very much, Mr. Delafield. We appreciate it. If we hadn't hadn't been a pandemic, we would come down and shake hands with counsel and thank you for your help and speak to you personally, but we're not following that process these days. But I'll thank both of you for your help and for your work, and we'll take the matter under advisement. And with that, Madam Clerk, we'll adjourn court until tomorrow morning.